are what a reasonable officer knew in Officer Potter's position. That's exactly what this witness testified to. A reasonable officer in Officer Potter's position would have known that he had been identified and could be potentially apprehended later. He didn't guarantee it was going to happen. He said that a reasonable officer would have known that. Now, that might have been wrong. That's not what he's saying. What he's saying is a reasonable officer at that moment would have understood that. It doesn't change anything that there is the unknown incidents unknown to Officer Potter, because a reasonable officer in that position wouldn't have had that information. So no door has been opened to put in what is essentially character evidence under 404B. That's what they're trying to do here, is to make it look like Mr. Wright wanted to flee. That's not the issue. Right? The issue is what Officer Potter knew to apply that reasonable officer standard.
And there isn't any evidence that, obviously right now, that Officer Potter was aware that he had fled in the past and done whatever acts to evade warrants or whatever. If Officer Potter wasn't aware of that, I believe it's covered under my prior ruling that any prior bad acts, alleged bad acts on the part of Daunte Wright would not be admissible.
May I speak to that?
Yes.
Well, the expert has testified he's reviewed thousands of pages. We don't believe he's reviewed an inch-thick file on Daunte Wright on every time he gets arrested, he tries to escape. Every court appearance he misses. Every time he can get away, he can get away. And so now we have an expert who's articulated that this really shouldn't have been a lethal force matter. You know, no taser should have been shot because eventually we'll find this kid. I mean, that's his opinion. And it's false. We'll find him, he'll be easily arrested, no big deal. And so they've got an articulated opinion they put forth to these jurors. They're writing it down like crazy on their notes. A few of them are anyway. And we need to rebut the falsehood of that opinion. And, you know, I realize your ruling was that since you didn't know about certain things about Daunte Wright, you know, we're limited. But I briefed the 703 issue, and you didn't rule on that yet. Mm-hmm. And I was waiting for this issue to either not be brought up or to be introduced into evidence. And now they've introduced a false predicate into the trial. And a false inference and false facts denies us due process. NAPU versus Illinois. We either have to correct it, or if your ruling is that we can't ask about it, I have to move for mistrial, and we will come in after the break with a thick packet, and I'll make an offer of proof of every time this kid has run away and not been found.
Okay. All right. Mr. Frank, I'll let you just briefly.
Yes, Karen, please, thank you. And I will not pound on the table because I don't think I need to. You can see clearly what the real purpose of trying to offer this evidence is 404B. It's character evidence. But nonetheless, there has been no false impression given to the jury because the witness's entire testimony was couched in terms of what a reasonable officer would have done or known, or what would have been, what they would have done based on what that officer knew at the time. That's been the entire context of his testimony. He never misrepresented that to the jury. He never said, you know, that he was guaranteeing they would have caught him later. That's not his opinion. So his opinion was carefully stated, appropriately stated, and did not open the door to any of this stuff, whether it's an inch thick or not. None of it was known to Officer Potter, and it's not relevant to the issues in the case. Okay.
I'm going to take a break and think about that. So I'll be back in 5 minutes, and I'm just going to read his expert opinions again. And I am concerned about this because I do think that the jury has gotten the impression that he could have easily been apprehended later. And there is a basis for believing that he wouldn't have. So I'll take a break. I'll be back in 5.
All right, interesting stuff right there that we were just hearing, where the judge now is going to take a break and decide on this motion here, where the defense wants to bring up the fact that Daunte Wright in the past has fled from police. They want that to be brought into evidence because they are fearing, because of the witness that was on the stand talking about